Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy Thanksgiving to everyone. We've got an eclectic group of cases this week, so we'll just start with the BIA and continue on in circuit order. But stick around till the end, because we've got a doozy from the Ninth Circuit. Also, if you haven't gotten a chance to check out the interview with retired immigration judge Jaja DePaulo, please do, and let me know what you think. I hope the interview helps practitioners and non-practitioners alike. I know it helped me. Finally, parental advisory warning for the podcast. This week, we've got an active circuit split gong. Starting off, we have matter of Padilla Rodriguez, published by the Board of Immigration Appeals. With this decision, the BIA entered the circuit split regarding whether TPS qualifies as an admission under immigration law. In this case, the BIA has disagreed with the 6th, 8th, and 9th circuits, and held that in all circuits besides those circuits, a temporary protected status recipient who entered the U.S. without authorization has not been, quote, admitted under immigration law, and therefore cannot adjust to lawful permanent resident status even if they have a qualifying relative, like a U.S. citizen spouse. Mr. Padilla Rodriguez is from El Salvador and entered the U.S. unlawfully in 1999. He received TPS many years later, but USCIS terminated his TPS in 2012. DHS charged him as removable under INA Section 212A6AI as a non-citizen who entered the U.S. without being admitted or paroled. Although this case doesn't arise in the Ninth Circuit, the immigration judge refused to sustain the charge of removability and terminated proceedings based on the Ninth Circuit's decision in Ramirez v. Brown, in which the Ninth held that TPS is an admission. DHS appealed, and the BIA sustained the appeal in this decision. In holding that TPS does not negate a finding of IWI removability under Section 212A6AI, the BIA purports to reaffirm its 2010 decision, matter of Sosa Ventura. And here, quote, when the respondent's TPS was terminated, he was no longer protected from execution of a removal order based on his inadmissibility as an alien who has not been admitted to the United States, end quote. Okay, fine. His TPS was terminated, so he's removable. But the BIA also went further. Even though Mr. Padilla Rodriguez did not apply for adjustment of status, and even though the BIA expressly recognized this fact, the BIA addressed his potential eligibility for adjustment of status under Section 245A. That discussion is therefore dicta. Addressing that issue in dicta, the BIA agreed with the AAO's decision last year in matter of HGG, and held that, quote, within the broader context of Section 244 of the INA as a whole, The best reading of the statute is that Congress intended to protect aliens who maintained a lawful immigration status prior to acquiring TPS from becoming ineligible for adjustment of status if their lawful status expired while they remained in the U.S. in TPS, end quote. But the grant of TPS, according to the BIA, does not satisfy the admitted or paroled requirement under INA Section 245A to adjust to LPR status. In conclusion, quote, an alien whose TPS continues to be valid is considered to be admitted for purposes of establishing eligibility for adjustment of status within the jurisdictions of the 6th, 8th, and 9th Circuits. However, we agree with the circuits holding that a grant of TPS is not an admission, and we conclude that their reasoning should be applied in any circuit that has not addressed that issue, end quote. Here's a bit more on the state of TPS and adjustment of status. So, with this decision, if it wasn't already going to happen, the issue of TPS admission is surely heading for the Supreme Court. And the dispute before the Supreme Court will likely turn on whether the immigration statutes are actually ambiguous regarding whether TPS qualifies as an admission for purposes of adjustment of status. The 6th, 8th, and 9th Circuits have held that the statute is not ambiguous on this issue. This is important because if it's ambiguous, the BIA's interpretation governs under the Supreme Court's Chevron and Brand X decisions. But if the statute is unambiguous, the BIA must defer to the interpretation of the circuit where removal proceedings originate. So practitioners, preserve the issue in all circuits, even if your circuit has ruled against your argument because, again, the Supreme Court is probably going to rule soon. And certainly argue the matter in any circuit that hasn't yet spoken. Because even with this decision, if a circuit eventually agrees with the 6th, 8th, and 9th Circuits that the statute's text compels a finding that TPS is an admission for adjustment purposes, the circuit's decision, and not the BIA's, governs. Next, what the BIA did here is pretty important and smart. As the BIA somewhat recognizes, matter of HGG from the AAO was vacated and remanded by a federal district judge in Minnesota 2 months ago, and therefore would appear to have no binding effect anywhere. Arguably, and I'm loath to make USCIS's argument, but arguably that doesn't matter anymore, because BIA decisions bind USCIS, and now the BIA has spoken. But again, they've spoken in dicta on the adjustment issue. I personally am unaware of anything that definitively binds USCIS to this interpretation of the word admission for adjustment of status purposes, other than in the 11th Circuit and possibly 3rd and 5th Circuits, where those circuit courts have spoken. So keep making the argument before USCIS, too. Finally, and I just want to note, this is another complicated decision that has a significant impact on immigration law and the lives of tens, if not hundreds of thousands of individuals in the U.S. But the respondent in this case did not have an attorney, and the BIA did not issue a call for amicus briefing on the issue. I just don't get it. And that is matter of Padilla Rodriguez. Next, we have Bedoya v. Barr, published by the 4th Circuit on November 25, 2020. This case is about asylum and past persecution. Mr. Bedoya and his wife and child are from Colombia. As a police officer in Colombia in the 1990s, Mr. Bedoya investigated FARC rebels, and the information he gathered was used to kill at least 3 FARC members. He received death threats from the FARC, and some were relayed to him by his friends. Shortly after he was transferred to another town, the FARC killed Mr. Bedoya's friend, and after 20 years on the force, Mr. Bedoya retired. But upon his retirement, he received multiple death threats in writing, letters, and text messages. He filed a complaint with the police, but no investigations were ever initiated. Scared for his life, Mr. Bedoya and his family came to the U.S. on tourist visas in 2013, and they overstayed. Before their authorized status ran, however, they affirmatively applied for asylum with USCIS. USCIS did not grant the applications and sent the matters to immigration court. In court, Mr. Bedoya claimed asylum as a member of the particular social group, former Colombian police officers. and IJ and then the BIA found primarily that the threats did not constitute past persecution and were not sufficiently severe to warrant a future persecution finding, particularly as they occurred over a nearly 20-year period. The Fourth Circuit disagreed. Simply put, under the precedent of the Fourth Circuit and many other circuits, quote, "A threat of death qualifies as past persecution," end quote. The Fourth Circuit has held that 3 threats, while not required, suffice, and that, quote, "Parallel threats directed at the asylum applicant's family members strengthen the objective reasonableness of the applicant's fear," end quote. With that standard in mind, the 2 letters and 3 text message threats that Mr. Bedoya and his family received certainly cut it, even though they never expressly used the word kill. The BIA erred in holding that to constitute past persecution, Mr. Bedoya needed to show something more than the death threats. And as to the extended period of time between threats, rather than undermine his claim, the Fourth Circuit held that it kind of bolstered it, and in any event, quote, "If FARC is targeting former Colombian police officers for their past actions, there is inevitably going to be a time gap between the actions of such officers and when an officer retires," end quote. The case was therefore remanded. Congratulations to Bradley Bruce Banias from Mount Pleasant, South Carolina, for petitioners. So great case for asylum seekers. One simple question. What would have happened if Mr. Bedoya had, as part of his police duties, given FARC members money or support in an effort to make them assets of the Colombian government against the FARC? Well, according to the 11th Circuit's recent decision in Hincapi Zapata v. U.S. Attorney General, that would be material support of terrorism. But doesn't the intent of the support matter? We now know based on the case law that there is no de minimis or duress exception to the material support of terrorism bar. But can one support terrorism when their actions are in fact designed to undermine a terrorist organization on behalf of a U.S. ally such as Colombia? Our firm had such a case a couple years ago, and while we were ultimately successful, no appellate body ever ruled on the legal issue. One day, maybe we'll find out. And that is Bedoya v. Barr. Moving on, we have Hernandez-Serrano v. Barr, published by the Sixth Circuit on November 24, 2020. This case is about administrative closure. Judge Clay dissented. In this case, the Sixth Circuit majority held that then Attorney General Jeff Sessions' interpretation of the immigration regulations as not providing authority for IJs and the BIA to administratively close cases was a reasonable interpretation of the regulations. In so holding, the Sixth Circuit has created a circuit split with at least the Fourth and Seventh Circuits on administrative closure. Mr. Hernandez-Serrano entered the U.S. unlawfully at 16 years old and was placed in removal proceedings. During those proceedings, a state court in Tennessee found him to be a court dependent, eligible for long-term foster care due to abuse, neglect, or abandonment, making him potentially eligible for Special Immigrant Juvenile Status, known as SIJ. This is a special procedure and status applicable only to minors, which potentially puts Mr. Hernandez-Serrano on the path to a green card. Mr. Hernandez-Serrano submitted his petition for SIJ status and an application to adjust status before USCIS. But because he was in removal proceedings, he moved the immigration judge to administratively close his case, to provide USCIS time to adjudicate his SIJ petition and adjustment of status application. Although the decision doesn't say it, Mr. Hernandez-Serrano was probably designated an arriving alien when he came to the United States, meaning that only USCIS and not the IJ has authority to adjust his status to that of an LPR, even if the SIJ petition is approved. The IJ denied the motion, and, without the SIJ petition yet approved, Mr. Hernandez-Serrano wasn't eligible for any other relief, so the IJ ordered him removed. He appealed to the BIA, and 3 weeks later, USCIS granted his SIJ status petition. With the approved petition in hand, Mr. Hernandez-Serrano was now potentially eligible to adjust to LPR status. He therefore moved for a remand to the IJ, but the BIA denied the motion, finding that regardless of the approved petition, IJs and the BIA lack authority to administratively close cases, based on then Attorney General Sessions' recently published decision in matter of Castro-Tum. Before the Sixth Circuit, Mr. Hernandez-Serrano challenged the finding that IJs and the BIA lack authority to admin close. Or, as the Sixth Circuit defined the question, whether the Sixth Circuit must defer, using the standard outlined by the Supreme Court in its recent Kaiser decision, to Attorney General Sessions' interpretation that the regulations do not allow IJs and the BIA to admin close cases. And the Sixth Circuit so deferred. In the majority's view, quote, "In hundreds of thousands of cases, administrative closure has amounted to a decision not to apply the nation's immigration laws at all," end quote. Admin closure violates an IJ's regulatory duty to, quote, "resolve the questions before them timely," end quote. Matter of Castro-Tum and Attorney General Jeff Sessions' interpretation that the regs don't allow for admin closure therefore stands in the Sixth Circuit. Judge Clay dissented, finding that the regulations unambiguously allow for administrative closure, and in so holding, quoted and relied upon KKTP's very own associate attorney Elizabeth Montano's publication in the Yale Law Journal Forum. Liz, we are so proud. Bad case for administrative closure, but here's some good stuff. So here's a big footnote. In a Rule 28J letter, Mr. Hernandez-Serrano argued that admin closure was necessary here because without it, and unless the BIA reopened proceedings, the regulations would preclude Mr. Hernandez-Serrano from adjusting status before USCIS. And that's because 8 CFR Section 1245.2A1I states that as to a non-citizen, quote, who has been placed in removal proceedings, other than an arriving alien, the immigration judge hearing the proceeding has exclusive jurisdiction to adjudicate any application for adjustment of status the alien may file, end quote. But the majority and dissenting Sixth Circuit judges in this decision rejected that argument, stating that, quote, once the proceedings have ended, the immigration judge's exclusive jurisdiction to adjudicate any application for adjustment of status likely ends as well, end quote. Or in other words, practitioners, according to the Sixth Circuit, USCIS is wrong when it says, all the time, that it lacks jurisdiction to adjust a non-citizen with a final order of removal unless the final order is reopened. Rather, it would appear that an adjustment of status application plus an I-212 waiver would suffice. It's not a jurisdictional issue. Only in a footnote, but that's huge. Email me if I'm wrong. Finally, Judge Clay, in dissent, cites an unpublished Fifth Circuit case prohibiting matter of Castro-Tum from being applied retroactively. So make that argument too, y'all. And that is Hernandez-Serrano v. Barr. Heading to the Seventh Circuit, we have Barrados-Zarate v. Barr, published on November 24, 2020. This is a short case about non-LPR cancellation of removal and issue exhaustion. Mr. Barrados-Zarate is from Mexico and has lived in the U.S. for over 2 decades. In removal proceedings, he was found removable, but claimed that if he was removed, his 2 U.S. citizen children would suffer exceptional and extremely unusual hardship, the standard required of non-LPR cancellation of removal under INA Section 240A-B. If successful, this would provide Mr. Barrados-Zarate with LPR status. As the basis for his claim, he asserted that the children would accompany him to Mexico, where they'd live in a, quote, rural area with poor health care, deficient educational opportunities, fewer available jobs, and a high crime rate, end quote. The IJ held that this does not meet the exceptional and extremely unusual hardship standard, and the BIA affirmed. And the Seventh Circuit affirmed the BIA. First, it held that Mr. Barrados-Zarate could not challenge the BIA's failure to discuss Mexican crime rates, because he hadn't challenged that finding on his appeal to the BIA. Quote, Whether or not the board could raise the subject on its own, it was not legally obliged to do so, end quote. This, according to the Seventh Circuit, meant that Mr. Barrados-Zarate failed to exhaust his administrative remedies as to that sub-issue. And because this was the only issue asserted on petition for review, the Seventh Circuit dismissed the petition. Short case packed with legal analysis. Here's one more observation. So this decision is really about appellate jurisdiction and issue exhaustion. And circuits generally lack the authority to review decisions to grant or deny cancellation of removal. Although Mr. Barrados-Zarate failed the standard in this case, it's worth noting that the Seventh Circuit has, quote, treated deficiencies in the board's opinion writing as legal errors, reviewable under INA Section 242A2D, end quote. So that is the standard to use to try to challenge the denial of relief otherwise barred from petition for review, and at least in the Seventh Circuit. And that is Barrados-Zarate v. Barr. Continuing on with short cases, we have Moallin v. Barr, published by the Eighth Circuit on November 23rd. This case is about deferral of removal under the Convention Against Torture. Mr. Moallin is from Somalia and entered the U.S. as a refugee in 1995. He obtained criminal convictions and was ordered removed in 2004. But he was not removed, and in 2017, an immigration judge granted his application to reopen proceedings so that he could apply for Convention Against Torture deferral of removal, apparently based on changed country conditions in Somalia related to al-Shabaab. But the IJ ultimately denied CAT deferral, and the BIA affirmed. As did the Eighth Circuit. It held that the IJ and the BIA did not err when it analyzed the risk of all potential factors pertaining to torture harm individually, so long as the agency also, quote, ultimately considers all factors together, end quote. The Eighth Circuit also reaffirmed that a government's willful blindness to the torture by private actors will suffice to warrant CAT protection. Here, however, Mr. Moallin did not establish that he'd more likely than not be tortured by al-Shabaab, or that the Somali government is willfully blind to the torture Mr. Moallin fears from al-Shabaab. So, the petition was denied. Short case. Finally, we come to Vega-Anguiano v. Barr, published by the Ninth Circuit on November 24th, 2020. This case is a very complicated decision about reinstatement of removal orders. It was first published in November 2019 BP, or Before Podcast, and has now been amended, denying a petition for a hearing en banc. Mr. Vega-Anguiano came to the U.S. from Mexico without authorization as a child, and, at 17 or 18 years old in 1991, was convicted of California possession of cocaine. This barred him from becoming a lawful permanent resident through his U.S. citizen spouse, and he was ordered removed by an immigration judge in 1998. But he was not removed, and the next year in 1999, his conviction was expunged, pursuant to Cal Penal Code Section 1203.4, a rehabilitation statute. Nevertheless, he was physically removed to Mexico in 2008, 10 years later. He entered the U.S. unlawfully a couple of weeks after that, and remained undetected for a long time, and in 2013 filed a motion to reopen his 1998 removal order. As the basis for that motion, he argued that the 1998 removal order was no longer valid, and that the time to file such motion should be tolled because his attorney was ineffective in 2008 for not filing a motion to reopen before his removal. The BIA denied that motion, and the Ninth Circuit affirmed the denial. Then in 2014, Mr. Vega-Anguiano was convicted under 18 U.S.C. Section 4 for misprison of a felony. ICE then reinstated the 1998 removal order, which essentially means that ICE proved that Mr. Vega-Anguiano was Mr. Vega-Anguiano and that a removal order existed against him. That means he gets physically removed without another hearing in immigration court because, again, there's already an outstanding removal order against him. Upon reinstatement, Mr. Vega-Anguiano collaterally attacked the underlying removal order. Procedurally, I believe this means that he requested a hearing before ICE and then filed a petition for review with the Ninth Circuit. And that's what this decision is all about. Here, the Ninth Circuit, relying on its own precedent and the BIA's precedent many years ago in matter of Farinas, stated that, quote, a collateral attack is largely reserved for cases in which the removal order could not have withstood judicial scrutiny under the law in effect at the time of either its issuance or its execution, end quote. Emphasis in the original. The Ninth Circuit has held in the past and has now reaffirmed that it has jurisdiction to review a, quote, collateral attack on an underlying removal order during review of a reinstatement order if the petitioner can show that he has suffered a gross miscarriage of justice in the initial deportation proceeding, end quote. Okay, but Mr. Vega-Anguiano's removal order was issued in 1998. Doesn't matter here, because the Ninth Circuit held that, as it has jurisdiction to review a final order of removal where the petition is filed within 30 days of the final order, quote, the phrase final order of removal covers both a final order and a final reinstatement order, end quote. According to the Ninth Circuit, it has jurisdiction to review challenges to a reinstated order of removal where challenged within 30 days of the finality of that reinstatement. The decision is not quite clear, but I suppose that means within 30 days of ICE's final action on reinstatement. And a side note, it appears that other circuits have held that the 30-day clock starts ticking once the removal order is final, which in this case would have been 1998, saying nothing about a restart of the clock if the order is reinstated. So while I don't think that this issue has actually been addressed in other circuits, beware. So, returning to the substance of this decision. Quote, because the conviction on which Mr. Vega-Anguiano's removal was based had been expunged in 1999, there was no valid legal basis for the removal order at the time of its execution in 2008, end quote. That Mr. Vega-Anguiano did not assert such a claim for over a decade after he could have is irrelevant because according to the Ninth Circuit, under Ninth and BIA precedent, there is no diligence requirement to bring such claims. All of this means that ICE's execution of a reinstated removal order, should it succeed in returning Mr. Vega-Anguiano to Mexico, would be a, quote, gross miscarriage of justice, end quote, meaning Mr. Vega-Anguiano wins his petition for review. The 1998 removal order cannot be reinstated. It appears that ICE must either begin new removal proceedings against Mr. Vega-Anguiano or simply let him remain in the U.S. Lots going on here, and quite a few judges had their say in concurrence and dissent. But that's the gist of it. Here's some more on the complicated world of reinstatement and conviction expungement. First, more research would be needed, but it seems to me like there is a valid argument, based on the law in many circuits and even before the BIA, which means binding on all immigration agencies, that even without a motion to reopen, any attempt to execute a removal order based on a finding that can no longer be sustained is a, quote, gross miscarriage of justice, end quote, and therefore can't be done. For example, if the categorical approach changes such that the underlying conviction is no longer a removable offense, the removal order arguably can't be executed, because again, to do so would be a gross miscarriage of justice. That argument might not succeed in reopening a case on a motion to reopen, but as this decision seems to show, that doesn't preclude an argument that the removal order can't be executed. Interesting. Shifting to expungement of convictions. The reason for the expungement of the cocaine possession conviction in this case and its effects under immigration law is a complicated issue in the Ninth Circuit, governed primarily by the Ninth Circuit decisions Lujan Armendares v. INS and Nunez Reyes v. Holder. I urge practitioners to review those decisions if your client has a potentially relevant conviction. As a starting point, however, the quote to remember is this, quote, For convictions occurring prior to July 14, 2011, the government may not remove an alien on the basis of a simple drug possession conviction if the conviction has been expunged under a state rehabilitative statute and the alien has satisfied the requirements of the Federal First Offender Act. To qualify for this exception to removability, the alien must show that 1. The conviction was his first offense, 2. He had not previously been accorded first offender treatment, 3. His conviction was for possession of drugs or an equivalent or lesser charge, such as possession of drug paraphernalia, and 4. He received relief under a state rehabilitative statute. End quote. And finally, remember, unless you're collaterally attacking a reinstated removal order, the only real thing to prevent removal if ICE decides to reinstate a prior order is a motion to reopen, maybe, or your client's reasonable fear of persecution or torture, which, if satisfied, would then lead to initiation of withholding-only proceedings. And that is Vega-Anguiano v. Barr. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.